Hello everyone, I am Pragati Parasar. I am from Hooghly Mohsin College and I am legal intern of LEXIS and Company. In this video, I am going to describe the primary evidence and secondary evidence under the Indian Evidence Act. So, Section 61 of Indian Evidence Act says that the content of document can be proved by two ways. One is primary evidence and second point is secondary evidence. It means that there is no other prescribed method by law the providing content of document in two ways, primary and secondary evidence. What is primary evidence? Section 62 of Indian Evidence Act says that primary evidence means original document itself. When the original document is produced before the court as a evidence, then it is called as a primary evidence. So it may be a original property paper, it may be a original will, original account paper is produced before the court for proving a certain case or certain matter, then it is termed as a primary evidence. It also include if a document is executed in various parts, then each part of document is treated as a primary evidence. For example, the registry of a property may be done by the several parts, may be done in several parts by different co-owner. So each part is treated as a primary evidence. If a number of documents are made by one uniform process, then each such document is termed as a primary evidence. For example, the printing of 50 photographs at once is treated as a primary evidence. Each photo is also a primary and is treated as a primary evidence. So primary evidence means original document which is produced before the court for explaining something and for use as a evidence for explaining something is called as a primary evidence. It may be done if it is done by the different co-owners, then each part of the document is treated as a primary and termed as a primary evidence. So what is secondary evidence? Secondary evidence is defined under section 63 of Indian Evidence Act. The evidence which is not a primary is called as a secondary evidence. So a certified copy of original document is termed as a is used as a secondary evidence. The copy that are made from original with the mechanical process, then it is a called as a secondary evidence. So copies made for the original or compared with the original document is also treated as a secondary evidence. A copy made from a copy of original document is termed as a secondary evidence. So counterpart of any document which is signed or acknowledged by the party is also termed as a secondary evidence. If a person who has himself seen a document and gives a oral account of it is also termed as a secondary evidence. So what is primary evidence? That original copy of any document is termed as a primary evidence, and the document which is not a primary is a secondary evidence. Like certified copies of original document is also a secondary evidence. So this is all about the primary evidence and the secondary evidence, which comes under the Indian Evidence Act, and it is used as evidence before the court. Thank you.